For example, suppose they decided that they drew up a written contract that has, say, 15 clauses, and one of those clauses is illegal or unenforceable from the standpoint of current legislation or some international acts. What would the judge do then?
Well, in this case, that clause is simply considered null and void. And if this contract is enforceable without that clause, then the contract remains in full force and effect in all other respects.
And if this leads to the entire document, the whole contract, being void, what happens then?
Then that contract will be rendered completely null and void.
If the contract is invalid, then accordingly the transaction doesn't take place. And then the question of damages really does arise. The question arises
Yes.
about the return of everything that was received or unjust enrichment and so on. Absolutely. And what else can be noted in the context of a contract? What other aspects are important?
Well, consequences are one of the things worth thinking through when entering into a contract. It is also important to decide on the jurisdiction and applicable law, because in this modern globalized era, many deals are made that go far beyond national boundaries, that is, companies registered in other jurisdictions. Accordingly, in our work, we more and more often encounter the application of European law, but sometimes the law of third countries can also apply. It's a complex topic. It's regulated by laws, conventions, and so on. And one must think through such consequences here.